The legal tug-of-war in the Romeca Meeks murder case has reached a boiling point. On one side, defense attorney Ari Williams, relentless, strategic, refusing to accept defeat. On the other, the Cook County State's Attorney's Office, equally determined to keep Holly Johnson behind bars. When these two forces collide, the result is a legal chess match that has now reached the Illinois Supreme Court. What happens when an appellate court reverses its own ruling, ordering a hearing for release conditions? What happens when the prosecution immediately slams the brakes, filing an emergency motion to freeze that decision? And what happens when the defense fires back, demanding the pause be lifted and citing constitutional due process violations? Today we're breaking down every move, every filing, and every implication. You're going to learn what a stay of the mandate really means, why the prosecution is rushing to the Supreme Court, and why one appellate judge called the majority's decision reckless. Before we dive in, this is True Crime Unraveled. Hit subscribe on YouTube and follow us on Facebook and Instagram at True Crime Unraveled TV. Your engagement keeps this case in the spotlight. Now, let's get into it. Let's start with what no one disputes. On September 8th, 2025, at approximately 9 a.m., 31-year-old Romeca Meeks Blackman dropped her 7-year-old son off at school near Cermak Road and State Street in Chicago's South Loop. She had written him a note that morning, "Happy Monday, son. Always remain yourself. You're the coolest, smartest, and funniest kid I know. I'll see you when you get home. Love, Mommy." She never came home. Within minutes, she was shot twice at close range, once in the face, once in the thigh, by Quadaja Holly Johnson. Romeca was unarmed. She was pronounced dead at Stroger Hospital. Holly Johnson was arrested at the scene, but released the same day due to her concealed carry license and claim of self-defense. On December 4th, 2025, she was rearrested and charged with 6 counts of first-degree murder. Since then, 3 bond hearings have resulted in 3 denials. Judge Clancy has repeatedly ruled that Holly poses a danger to the community. And that brings us to where we are today, standing at the doorstep of the Illinois Supreme Court. Today, we're going to try this case from both perspectives. You are the jury. Before we present the arguments, let's understand a critical legal term. A mandate is the official order from an appellate court that tells the lower court what to do. A stay is a pause, a freeze. So a stay of the mandate means the appellate court's order is temporarily frozen. Nothing moves forward. The case sits in limbo. Under Illinois Supreme Court Rule 368C, a party can request a stay while they seek review from the higher court. That's exactly what the prosecution did here. They asked the appellate court to pause its own ruling while they take the case to the Illinois Supreme Court. And on April 24th, the appellate court granted that stay. Now, the defense is fighting back, asking the court to reconsider, to lift the pause and let the case move forward. This is the legal battleground we're about to explore. Now, let's present the prosecution's arguments as they would in court. The state's attorney's office has 6 counts of first-degree murder. They argue that Holly Johnson is exactly where she belongs, behind bars. Here's why. First, the nature of the crime. This was not a heat-of-the-moment fight. Witnesses say Holly verbally announced she was going to shoot before retrieving her gun. That's premeditation. She walked to her car, got the weapon, walked back, and fired multiple shots at close range. The pause between shots suggests time to think, not blind panic. Second, the victim was unarmed and not advancing. Under Illinois self-defense law, deadly force is justified only when a person reasonably believes it's necessary to prevent imminent death or great bodily harm. Romeca had no weapon. She was not charging. She was being physically restrained by Carlos Smith when the shots were fired. That's not self-defense. That's execution. Third, the fist bump. After the shooting, multiple witnesses reported seeing Holly and Carlos fist bump. That's not the behavior of someone in shock. That's the behavior of coordination and celebration. Fourth, the school zone. This happened across the street from a school. Children were present. Teachers were arriving. The risk to public safety was immediate and severe. Fifth, the evidence of planning. Phone records show a 3:40 a.m. call between Holly and Carlos on the morning of the shooting. The prosecution argues that call was about coordinating the confrontation. Sixth, the social media evidence. Holly's family posted videos of gatherings with 5 handguns displayed like party decorations. A relative wrote, "Johnsons don't fight, we shoot people in the face." Her alleged best friend described Holly as someone who would put bitches in the head over Carlos.
They seen the video, everything. They was leaving his house. She was seen in the school here. She did. They'll be like, yeah, she was crazy, man. We gonna miss her. She was crazy. They're not gonna say, oh, she was just a sweet, innocent little angel, knowing that I was doing drive-bys and putting bitches in the head like every month. And be fucking for real. Be the fuck for real. Oh, she was just a sweet angel. She wouldn't kill a bug. Meanwhile, she got every bitch in the head like over this nigga. What? You say happy birthday with 3 emojis to Carlos, you're getting beat the fuck down. That bitch ain't play about Carlos. What?
And photos from November 8th, a day the community wore pink in Romeca's memory, show Holly partying, beaming, holding a drink while claiming to be pregnant. The prosecution's bottom line: this was not an accident. This was not self-defense. This was a planned, coordinated act of violence. Releasing Holly Johnson, even with electronic monitoring, poses an unacceptable risk. Judge Clancy got it right. The appellate court's reversal was wrong. And that's why they're fighting to keep her detained. Now, let's flip the script. Here's how defense attorney Ari Williams would argue her case. First, the appellate court already ruled in Holly's favor. On April 20th, 2026, the Illinois Appellate Court reversed Judge Clancy's detention order. 2 out of 3 judges found that the state failed to carry its burden of proving that Holly's release poses such a significant threat that no conditions could mitigate it. That's not a minor procedural victory. That's a judicial finding that the prosecution's evidence was insufficient to keep her locked up before trial. Second, the facts that the court cited. The appellate court noted that it is undisputed Holly did not seek out the confrontation. She was present because she had a right to be there. The court also cited her pregnancy, arguing that she needs the opportunity to prepare for birth and that Cook County Jail's facilities, while adequate, cannot replace the medical care available outside. Additionally, the court noted that Holly remained at the scene after the shooting, which is evidence of good faith, not flight risk. And the court pointed out that she was free for 3 months between the shooting and her arrest without any new incidents, demonstrating that she is not an ongoing threat. Third, the self-defense claim has merit. Evidence shows Romeca had threatened Holly for months, including allegedly calling Holly's grandmother and saying she intended to kill her. Holly had filed an order of protection. Even if it wasn't served, it demonstrates her genuine fear. On the day of the shooting, Romeca was the aggressor. Holly, pregnant and with her infant in the car, reasonably believed her life was in danger. Fourth, the prosecution's evidence is not as strong as they claim. The fist bump? The defense argues it was a high-stress reaction, not a celebration. The phone call at 3:40 a.m. could have been about anything. Arranging a car swap, discussing their children. The social media posts? They're from family members, not from Holly herself. She cannot be held responsible for what her relatives post. Fifth, conditions of release can protect the public. Electronic monitoring, GPS tracking, surrender of her passport and firearms, no contact orders. These are standard tools that courts use every day. If they work for other defendants, Why not for Holly? 6. Due process matters. Keeping Holly detained while the state delays filing its appeal to the Supreme Court is unconstitutional. Under Illinois Supreme Court Rule 368B, the mandate is automatically stayed only if a party actually files a petition for review. Here, the state has not yet filed that petition. They asked for a stay without submitting the actual appeal. The defense argues that indefinite detention without that filing violates Holly's 14th Amendment rights. The defense's bottom line, the appellate court spoke. The state failed to prove its case for detention. Holly should be released with conditions. Any further delay is a violation of her liberty. Now you're the jury. Let's go into the jury room. From the prosecution side, the strongest point is the gravity of the offense. 6 counts of first-degree murder, an unarmed victim, a school zone, a fist bump. That combination is hard to dismiss, regardless of conditions. From the defense's side, the strongest point is the appellate court's finding. 2 judges reviewed the same record and concluded the state did not meet its burden. That's not nothing. That's a judicial determination that the prosecution's case for detention is weaker than they claim. So here's the question you have to answer. Does the presumption of innocence mean Holly should be released pending trial, even in a case this serious? Or does the danger she allegedly poses outweigh that presumption? Now, let me give you my analysis. The prosecution made a deliberate strategic choice by skipping a rehearing request and going directly to the Supreme Court. That tells me they believe this appellate ruling is legally flawed enough that the highest court in Illinois might intervene. They are betting that Justice Mitchell's dissent, calling the majority's decision reckless, will resonate with the Supreme Court justices. But here's the risk for the prosecution. If the Supreme Court denies their petition for leave to appeal, the stay will lift, the mandate will issue, and Judge Clancy will be forced to hold a release conditions hearing. Holly could be out on electronic monitoring within weeks. That's a real possibility. For the defense, the risk is different. If the Supreme Court agrees to hear the case, Holly remains detained for months longer, possibly until the trial itself. And if the Supreme Court reverses the appellate court's ruling, the door to pretrial release slams shut permanently. The question that keeps me up at night is this. If a woman can be charged with 6 counts of first-degree murder, shoot an unarmed mother in the face across from a school, and still be granted pretrial release, what does that say about how we define danger to the community? And if the appellate court was wrong to reverse, why didn't all 3 judges agree? Why did Justice Mitchell dissent? These are the questions the Illinois Supreme Court will now grapple with. The bottom line is this. We are watching a legal battle that will set precedent. The prosecution has made its move. The defense has fired back. The Illinois Supreme Court will decide whether to step in. And until then, Holly Johnson remains in Cook County Jail, frozen in legal limbo. The question for you is simple. Do you believe the appellate court was right to order a release conditions hearing? Or do you agree with Justice Mitchell that the ruling was reckless? Vote in the poll. Comment below. We read every single one. If this dual perspective breakdown helped you understand the case, hit like, subscribe, and follow True Crime Unraveled on YouTube, Facebook, and Instagram. Share this video. Keep Romeca's name alive. For Romeca, for her son, for the truth. We'll see you in the next update.